you have a lot of members in the House who would like to have this be called an impeachment inquiry for reasons that don't have a lot to do with anything other than the PR of it. And there's a reluctance on the part of, or an inability on the part of the leadership to get the full House to vote for that.
I'm Quinta Jurecic, a senior editor at Lawfare, and this is the Lawfare podcast, October 3rd, 2023. If you've been following the news out of Congress recently, you've probably been focusing on the narrowly averted government shutdown, or the indictment of Democratic Senator Bob Menendez, and perhaps the House Republicans' decision to begin an impeachment inquiry against President Biden. But there have also been some notable updates when it comes to the continuing fallout from January 6th. Recently, the U.S. Court of Appeals for the D.C. Circuit unsealed an opinion limiting the ability of the Special Counsel's office to access phone records from Representative Scott Perry under the Speech and Debate Clause. Meanwhile, Trump's one-time advisor, Peter Navarro, was finally convicted of contempt of Congress for defying the January 6th committee. Along with my fellow Lawfare senior editor, Molly Reynolds, I sat down with two of our favorite guests to call when there's news about Congress and the law. Mike Stern, the former senior counsel to the House of Representatives, and Eric Columbus, who recently served as Special Litigation Counsel in the House Office of General Counsel. We discussed Perry, Navarro, how exactly one should define an impeachment inquiry, and, of course, the Menendez indictment. It's the Lawfare podcast, October 3rd, checking in on Congress. So we have a long list of topics to go through, from Representative Scott Perry's cell phone to the Peter Navarro contempt prosecution to what exactly impeachment means. Let's start with Scott Perry. So the litigation over Representative Perry's cell phone has traveled a long and winding road. And recently, the D.C. Circuit unsealed a ruling that rolls back in part a previous district court opinion that would have allowed investigators to access the phone's contents. And I do want to make sure we talk about the specifics of both of those rulings. But before we do, Mike, you've been following this case closely. How did we get here? Why was it that law enforcement was so interested in Perry's phone? And on what grounds has Perry been challenging that search?
So the law enforcement, the special counsel's office, has been interested in the contents of Perry's cell phone, I think largely because of his role in, I suspect, I don't really know this for a fact, but I suspect a large part of it has to do with his role in communications with the White House regarding the role of the Justice Department in January 6th, specifically installing Jeff Clark as the Attorney General. If you recall all of the events surrounding that, where Clark was introduced to the president by Perry, apparently. And then Clark was going to try to get the Justice Department involved in sending a letter to Georgia to ask them to call a special session of the legislature in order to look into allegations of fraud, which, according to this letter that he wrote, that he drafted, the Justice Department had found evidence of fraud that required these extraordinary actions. Again, as you may recall, his superiors Clark's superiors at the Justice Department were very opposed to that, and there was a huge meeting at the White House in which Trump was on the cusp of installing Clark as the new acting Attorney General, but eventually decided against it because everyone else in the Justice Department threatened to resign. So I think that's a large part. Perry's role in instigating that, I think, is a large part of why they are particularly interested in him. But they got a warrant for his cell phone and they seized it, and they want to get access to be able to look at a whole bunch of text messages on that cell phone. Perry's argument is that they are prohibited from doing that by the Speech or Debate Clause of the Constitution, which protects members of Congress from certain types of questioning outside of the legislature. And the legal question in the case is, which of these communications, if any, fall within the scope of the speech or debate clause? The district court, Chief Judge Howell, found that only a very small subset of the communications were protected in her view, those that involved his communications with other members, specifically regarding legislative matters. In contrast, she found that all of his communications outside of Congress with private individuals or state legislators or anything of that nature, even though they may have related to the January 6th and the question of whether electoral votes should be certified, she found those were unprotected. Perry claimed that they constituted informal fact-finding, and in Judge Howell's view, informal fact-finding, unless it is authorized in some way by the House itself. For example, if Perry had been on a committee that was conducting an investigation or had oversight over a particular issue, that might be protected, but just on his own, trying to get facts was not something in Judge Howell's mind that was protected. However, the D.C. Circuit took a slightly different view, and exactly what that view is somewhat unclear, but they remanded the case to her to look again at these communications with this different standard, which is a little hard to explain, but we can get into that as we discuss it.
So, Mike, you were just sort of outlining for us the ways in which this case ultimately hinges on interpretations of the speech and debate clause. And I'm curious to hear both of your thoughts. And Eric, maybe I'll start with you. Kind of how does the ruling in this case fit in with previous rulings by courts on the speech and debate clause? Is it consistent with where courts have generally been? Does it go in a different direction at all? That sort of thing.
Both the district court and the Court of Appeals cited extensively to cases by the D.C. Circuit and the Supreme Court in support of their basically opposite conclusions. I have not gone back and looked at line by line the citations to see who has the better case from precedent, but I think it's fair to say that it's probably somewhat uncharted waters, and you could kind of come out either way in that regard. One interesting thing here actually is that the typical partisan lines are a little bit scrambled. We have a Republican congressman, obviously, and he and Judge Howell, the district court, who is an appointee of President Obama, ruled against him. And then a 3-judge panel of the D.C. Circuit, all consisting of Trump and Bush appointees, ruled in his favor. So that, you might say, is completely quote unquote normal. However, the House moved to intervene in the case at the Court of Appeals level. And that in recent years is something that can be done on a partisan basis with just the majority party authorizing intervention. But in this case, it was reported that the Democratic leadership also agreed to intervene, even though it didn't really matter whether they did or not. So this shows that the House believes that it's in its institutional interest to protect Representative Perry here and to protect the ability to conduct informal fact-finding within and be protected by the speech or debate clause. Now, the briefs are sealed, so we don't know precisely what position the House took, whether it was the same as Representative Perry's. But I think it's fair to say that they would not have gotten involved if they were satisfied with what Judge Howell had done.
Mike, do you have thoughts on sort of how this ruling fits into the broader jurisprudence on the speech or debate clause?
Yeah, I agree with Eric that this is basically, these are open questions, and like good lawyers, they marshal the language in the cases that support the position that they want to reach. The question is, so there's one jurisprudential issue which is unique to the DC Circuit, which is that the DC Circuit recognizes what is just called a non-disclosure aspect of speech or debate. In other jurisdictions, it is unclear whether if you're seeking documents that you necessarily can assert speech or debate simply to protect the contents of documents, because it is viewed as not necessarily protecting the contents of documents as opposed to the questioning aspect of it. So, for example, if it's a search warrant or seizing a cell phone, arguably it might not be protected at all in other jurisdictions, and that's kind of an open issue that's specific to the DC Circuit. But in terms of whether informal fact-finding is protected, that's kind of an issue that there's a little bit of precedent on saying that it is protected, but there's not really much at a appellate court level. And so it's really kind of an open issue. Judge Howell thought it shouldn't be protected at all unless it was, again, part of some sort of formal connection to a House investigation. The DC Circuit appears to disagree, but they don't actually explain exactly. Judge Katsas, in a concurrence, kind of gives a hint as to what he thinks should be protected, and the majority says maybe that's right, maybe it's wrong, we don't need to decide that. So it's very unclear exactly what Judge Howell is supposed to do on remand, in my view, but she's supposed to go through every one of his texts, sort of text by text, and make a judgment on whether or not it falls within the legislative sphere, which is sort of a broadly defined concept. And I don't think the courts, maybe Eric has a better idea, but I didn't read the court as giving much guidance on how she should decide whether it falls within the legislative sphere or not.
Yeah, I agree with Mike on that. And Judge Howell actually kind of noted that anticipatorily in her opinion, where she said that it would be she was actually quoting Judge Kavanaugh from a different speech or debate clause case relating to a different issue. She wrote that it would be unwise in principle and unworkable in practice to have a rule that is similar to what the Court of Appeals did, and she noted that when Lindsey Graham challenged the Fulton County District Attorney's efforts to compel him to testify about his communications with the Georgia Secretary of State, the district court wound up engaging in what Judge Howell called painstaking parsing of what questions he could or could not be asked. So I would imagine that Judge Howell's blood pressure rose considerably when reading the Court of Appeals opinions for precisely the reasons that Mike noted and that she herself had warned about, that it's going to be very annoying for her to kind of go back and read through each of the texts and determine whether each specific text constituted a quote-unquote legislative act, as the Supreme Court has interpreted that term.
So when the appeals panel was unveiled, I imagine that a lot of lawyers on the government side might have been wincing. So the panel was made up of Judge Henderson, Judge Rao, and Judge Katsas, which is certainly a atypically conservative panel for the DC Circuit. Two of those judges, Rao and Katsas, are Trump appointees. I think there's reason to wonder, certainly, whether they might have been perhaps less sympathetic to the January 6th investigation. And Rao, in particular, has been a bit of a bomb thrower when it comes to investigations. We can talk about her previous rulings when it came to the impeachment questions. So I definitely, went into this opinion thinking, okay, this might be a bit of a wild read. And I have to say, I think I sent Molly a message while I was reading it saying that I found it disappointingly reasonable. That it seemed, at least in tone, they're walking through all the concerns. They're sort of presenting themselves as trying to map a middle path between Perry's approach, under which everything would be protected, and the government's approach and the district court's approach, which rules that very little is protected. So I'm curious what you both think of the sort of dynamics there, and whether, you think the DC Circuit got the answer right. Is it actually reasonable, or is it just kind of posturing reasonableness? Mike, let me start with you.
So I think it's interesting. I had a couple of reactions to Judge Rao's opinion. First of all, it seemed very unlike many of her other opinions, which are sort of extremely originalist, and even more than originalist, they're sort of original with her. They're her own takes on issues. And this one, in contrast, sort of walked through it basically just had a long description of what the cases said, and then said, well, that's what they say, so go and do likewise, without actually. And so the problem I had with the opinion was it didn't really explain how exactly you were supposed to apply these in the particular case. I didn't think it was necessarily unreasonable. I don't think it's unreasonable to say that some informal fact finding is protected and some may not be, but I'd like to hear some guidance on how you figure out, how you tell the difference. But I think that in terms of the impact of the opinion, my guess is that from the special counsel's sort of short-term view, it's probably fine, because I think it allows them to get what they are most likely most interested in, which is the communications with the executive branch. As I read the opinion, although there wasn't a lot specific about that, it seems like the court agrees with Judge Howell that those communications are not protected. And I think that's what the special counsel is most interested in. The problem that I think that the Justice Department more broadly may have is, how is this going to play in other cases? Every time we try to get information related to a member of Congress, are we now going to have to ask the court to conduct a text by text or a communication by communication review, which we're not sure exactly how it is supposed to work? That could, I think, be a problem for future Justice Department investigations. And I would imagine maybe they're discussing whether they want to try to take this on bank for that reason more than any particular relationship to this particular investigation. That was my reaction.
Jumping off from that, I think it's an interesting question. In some ways, this is perhaps an easier application of the principle that the DC Circuit tried to articulate, because it's very clear in this case that Representative Perry had an upcoming vote that was probably weeks away on January 6th to determine whether electoral votes should be counted, or rather, I should say, there wasn't necessarily going to be a vote. If there was an objection from one member of the House and one member of the Senate to a state's vote, then the parties these houses would separate and debate and vote. So it was a fair probability that he was going to vote on something on that day relating to the election. But what happens if, obviously members of Congress vote on everything all the time. So a member of Congress could be, asking questions about, or the member of Congress could retroactively claim that text communications were in the service of gathering information about some possible legislative issue that would come up in the future. And how concrete does the upcoming vote have to be? Does there have to be something basically scheduled in the way that January 6th was scheduled? Or can a member of Congress just claim that he thought that at some point there would be a vote on on this topic in the remainder of his term. It's a little bit like the question of when is a congressional investigation authorized, and the typical rule is that Congress can investigate anything on which legislation can be had, and that basically covers just about everything. And even if their actual intent is to embarrass or show up or shine a light on a certain issue, and so you wonder here whether this becomes such an easy test for a member to pass by claiming that there could be legislation on this topic and I was just gathering information about it.
Yeah. Or take something that happens all the time, which is members having discussions with lobbyists or interest groups that want to talk to them about upcoming legislation or potential legislation or what have you. This rule would presumably make all of those conversations potentially privileged, but I'm not quite sure how one decides whether they're privileged or not. So basically, it opens up a big can of worms, I think, for the Justice Department or for courts that are trying to evaluate speech or debate claims. It's probably good for Congress because it makes it harder for anyone to get information from them.
So I want to ask one last question on this before we turn to Peter Navarro. And that has to do with what this might mean for the January 6th investigation. At this point, I believe, Mike, you should correct me if I'm wrong, that Representative Perry's phone was seized in the spring of last year. We've now been waiting for quite some time for the Justice Department to get a crack at it. In fact, I think that the phone was actually seized even before Special Counsel Jack Smith was appointed.
That's
so
right.
It's been a while. So, Eric, I'll turn to you first on this. And Mike, I'm certainly curious if you have any thoughts about, what the DC Circuit ruling here means in terms of the special counsel's office, their investigative ability to pursue the investigation. Could you see this potentially being a significant problem, assuming that, they're still potentially looking into what's going on here? Or is the fact that, at this point, President Trump has been indicted, the case is before Judge Chutkan in the DC District Court, that all this is essentially moot by now anyway?
It's really hard to know. I think if the special counsel has no intention of indicting anyone beyond President Trump, it's former President Trump, then it would seem rather unlikely that this would be anything more than a drop in the bucket. Of course, I can't say that with any security, not knowing what the contents of the texts are. But if he were interested in possibly prosecuting Jeffrey Clark, who I believe is a unnamed co-conspirator, then this could be important information.
Yeah, I would agree with that. I think that, as I mentioned before, I think this allows the special counsel to get the information that it probably most is interested in, that is the communications with the executive branch, which would cover presumably anything related to Jeffrey Clark, to the extent that they're still conducting a more broad range inquiry into either Perry himself or other members of Congress. I think it will make it more difficult, and it'll make it more difficult for any future Justice Department investigations relating to members of Congress, period.
Although, Mike, what if like Jeffrey Clark has texts with Perry about, Clark is saying, look, the Italians had a satellite that stole votes in Pennsylvania or whatever, and Perry's like, this is interesting stuff, and tell me more. Wouldn't that possibly be a legislative act on Representative Perry's part if he was gathering the information to inform his vote?
Conceivably, yeah. I think so. What the DC Circuit said was that, and it was very much of an aside. So Judge Howell had basically said all of the communications with the executive branch were unprotected because they weren't information gathering at all. They were basically cajoling the executive branch to do things that Perry wanted them to do. And the DC Circuit, I think, agreed with that. So to the extent there are other communications with Clark or anyone else who might be associated with the executive branch that would fall more into this information gathering category, that then goes in with all the other information gathering communications as a open issue about how is supposed to decide that. So potentially it could be protected, but the sense one gets from Judge Howell's opinion and then from the DC Circuit's discussion of it is that the executive branch communications are outside the information gathering bucket entirely. But
that was specifically remanded, right, to Judge Howell. On page 2, the court writes, with respect to Perry's communications with executive branch officials and others outside of Congress, we remand for the district court to apply the standard from the Gravel case on a communication by communication basis.
Right. But based on what the court said, it seems as if Howell's rationale for not protecting the communications with the executive branch would stand. But as you said, if there's some that could fall within this information gathering category, that could be an issue.
Yeah, if it was, as you say, if it was just cajoling the executive branch, if it was information outbound requests rather than taking in information on Perry's part, then it would not be protected.
So I want to take us now to another January 6th related case, which involves Peter Navarro, who was cited by the House for contempt for not complying with the subpoena from the January 6th committee. He and Steve Bannon were both prosecuted for contempt. They were both convicted. Is there anything new that we should take away from Navarro's case that's different than what we learned from the Bannon prosecution? Eric, maybe I'll start with you.
Well, Navarro seems to be someone who has a great interest in losing his freedom and wants to see the confines of a federal detention facility. Unlike Steve Bannon, he does not have an argument on appeal that he relied on advice of counsel. Bannon had that argument. The judge in his case, Judge Nichols, concluded that it was barred by controlling DC Circuit case law, but he let Bannon remain free on appeal in order to pursue that appeal. Peter Navarro has no such argument, and he had very little arguments of any sort. So I would be surprised if the judge in his case, Judge Mehta, allows Navarro to remain free on appeal. Bannon was sentenced to 4 months and given an absurdly low $6,000 fine. It would be interesting to see what Navarro gets sentenced to. The facts are the same in terms of that they both really had no excuse not to show up, unlike Mark Meadows and Dan Scavino, who were the other two Trump officials who the House held in contempt for not cooperating with the subpoenas issued to them by the January 6th committee. Neither Navarro nor Bannon received letters from Trump instructing them to invoking executive privilege and instructing them not to testify. Now, there is some question as to whether that would suffice because Trump was a former president and the incumbent president, President Biden, concluded that it was not in the interests of the United States to invoke executive privilege for their cases. Navarro has perhaps the unique distinction in recent times of having blown off two entirely separate congressional committees. He also blew off a special committee created to investigate the administration's response to the coronavirus. And he blew them off as well. And he was not held in contempt for that. He sent, in his arguments before Judge Mehta, he pointed to a Truth Social post where Trump was ranting about the coronavirus committee and says, "I'm telling Peter Navarro not to cooperate with them." Words to that effect. And Judge Mehta looked at that and pointed out very reasonably that says nothing about the subsequent subpoena from the January 6th committee. And the jury did not waste that much time in finding him guilty.
So when I calculated how long it took between when Navarro was cited by the House and when the guilty verdict came down, I'm going to say it was something like, Quinta might remember because I told her, like 459 days.
I think it was 456 days.
456 days. Thank you. He will not be sentenced until January, which is to me just another reminder of how slowly these cases can proceed. Mike, I know you've sort of thought a lot about this. Is there anything we should take away from this case that might shape the House's interest in using its contempt tools in the future?
Well, I mean, just the fact that there have been convictions. I mean, remember, no one had been convicted for contempt of Congress before Bannon and Navarro since the 1970s. So I think that even though if one follows these cases in detail, you realize how narrow the path is to try to indict and convict an executive branch person, or in Bannon's case, a hanger-on, I guess. The fact is they did get convictions, and assuming that they are upheld on appeal, I would think that people will think a little bit harder before ignoring congressional subpoenas. But certainly the fact that Meadows and Scavino were not prosecuted shows how little one actually has to do to escape prosecution for if you're an executive branch official for contempt of Congress.
So speaking of executive branch officials and congressional investigations, let's talk about Molly's favorite subject, impeachment. What is actually happening right now with the Biden impeachment? I guess before we begin, I should say this is very much an impeachment inquiry in search of a reason to have an impeachment inquiry. The Republicans investigating, I think it's fair to say, have done quite little to justify the investigation. And so I certainly don't want to suggest any substantive comparison between this and the two Trump impeachments. For which there was plenty of evidence. So what is actually happening right now? Where is the House in terms of where things stand? Mike, let me start with you.
So I guess I'm going to start by taking a little bit of issue with what you just said with regard to whether there is enough evidence to justify an investigation. I think this is pretty much of a standard. If you look at the issues that they're looking at, this is pretty much of a standard congressional oversight investigation. I'm not going to go through all the evidence in detail, but there was evidence that the president's son was engaged in influence peddling with foreign clients and receiving millions of dollars, apparently for the sole purpose of whatever influence he could use with his respect to his father, and really very little else is claimed for why he was getting this money. I think that's more than enough to justify a congressional investigation. Now, whether it should be an impeachment inquiry or not, and what the line should be in that is, I think, a more difficult issue. What we have here, and I think this is in many ways analogous to the first Trump impeachment, is we have a situation where you have a lot of members in the House who would like to have this be called an impeachment inquiry for reasons that don't have a lot to do with anything other than the PR of it. And there's a reluctance on the part of, or an inability on the part of the leadership to get the full House to vote for that. And so what they've decided to do is declare an impeachment inquiry without actually having a formal vote. I think that raises two questions. One is the investigation itself and any subpoenas that they may issue, are those valid without a formal House vote on the matter? And the second question would get to what would be the legal impact of this being termed an impeachment inquiry as opposed to just a standard oversight inquiry. So that's what I think the principal issues are. My view is, with respect to the first question, that most likely this is a valid investigation and they can validly issue subpoenas, although I think they're wise to do it in a way that will preserve their right to also rely on the fact that it is an oversight investigation as well in order to protect the validity of their actions. But I think the strongest answer is that yes, this is a valid inquiry. Whether the fact you call it an impeachment inquiry or not matters is a different question that we can get to.
Yeah, so let's go there now, because in 2019, Mike, you and I also separately wrote about this one aspect of this question, which involves kind of what investigative powers come from a resolution adopted by the House authorizing an impeachment inquiry that House committees don't already have. So that's sort of one piece of this question, the sort of does it matter if you call it an impeachment inquiry question. So I'd be curious to hear both of your thoughts on that. And then we can also talk about sort of what has happened since then, particularly related to the Office of Legal Counsel. So maybe, Mike, I'll come back to you and then to Eric about kind of your views as an investigative matter. How important is it? What powers would an authorizing resolution really give the committees? In this case, it's largely the House Oversight Committee that's been doing most of this work. What powers would it potentially get from a resolution that it doesn't already have?
Right. So back in 2019, when we were first discussing this issue, or maybe even earlier than that, I guess early 2019, I think I wrote a piece basically talking about the potential advantages that a formal impeachment inquiry would give the House. Some of those have been somewhat reduced by the fact that the executive branch in the Trump administration, and I suspect will continue in the Biden administration, has said that we're not really recognizing a difference between impeachment and regular oversight with respect to things like absolute immunity, executive privilege, whether agency counsel are required to be able to attend congressional depositions. These are all legal positions that the executive branch had taken in the oversight context, but when the House declared that there was an impeachment inquiry in 2019, OLC said, well, we're still taking the same position, basically, on those issues. So potentially there could still be a difference if it ever gets to enforcement in court, but some of the advantages are attenuated by the positions that the executive branch has taken. I think there's still some areas where it clearly would be an advantage to the House for it to be considered an impeachment inquiry, whatever that means. So, for example, if they wanted to get grand jury material, as they did in 2019, having it be an impeachment inquiry would be significant because then you can argue that the exception for judicial proceedings, the exception to the secrecy of grand jury material can apply because an impeachment proceeding is a quasi-judicial proceeding. So that will help you in that area. I think another important and probably more significant area that it could help the House is with respect to subpoenas that raise the Mazars issues. So if everyone recalls, Mazars was a case, again, coming out of the Trump administration, where the House, in a non-impeachment context, was seeking to get Trump's personal financial records. And the Supreme Court held that there was a higher standard that applied to trying to get those kinds of records. Part of the rationale of that was that for legislative oversight, you don't really need to get the kind of specific factual information that you need in a judicial proceeding. And that would be different. That would arguably be distinguishable if you're in an impeachment inquiry, because obviously an impeachment inquiry is designed to discover and determine certain specific facts. It's not just about using a case study for general legislation. It depends on resolving particular factual events, very similar to a judicial proceeding. And so that, I think, is a potential difference that could be important. And whether or not a court would look at this, informal impeachment inquiry, if we can call it that, as having that advantage, I think I really don't know the answer to that. I think it's safe to say that the House would be better off if it had a formal vote, but whether or not it could, get a better Mazars standard in this context, I think is hard to say.
Yeah, Eric, I'm curious for your thoughts as well.
I agree with Mike in general on that. I just want to back up and explain a little bit about how we got here, just somewhat politically, but also interesting how the sides may or may not flip in some ways. So Speaker McCarthy announced by himself that the House had opened an impeachment inquiry. And this was just some number of days after he said he wouldn't do that without a full vote of the House. And indeed, in 2019, he had criticized Speaker Pelosi for doing just that, for announcing an impeachment inquiry unilaterally without a House vote. So McCarthy tried to be consistent. It's always good to be that way if you can, but his moderates wouldn't give him the votes, and his right flank was demanding that he do something, so he wound up doing the very thing that he had criticized Pelosi for. Now, the House under Pelosi did, in fact, vote to open an impeachment inquiry, I believe a month and a week after Speaker Pelosi had made her unilateral announcement. So the issue became a little bit moot, but it seems unlikely, based upon the politics, that McCarthy will be able to, anytime soon, can get a majority to vote for an impeachment inquiry. Now, the executive branch has taken the position that an impeachment inquiry is invalid unless there's a House vote. And this was expressed most recently by OLC in January 2020, which said that the House's impeachment inquiry was not properly constituted, and that any subpoenas issued pursuant to that impeachment inquiry before the House vote were null and void. And OLC also said, well, the House vote could have ratified the earlier subpoenas and made them valid, but the way it was worded, it didn't do so. So, I agree with the various, with Mike's analysis. I think there is some possibility that if it gets litigated over executive privilege, there could be some benefit to being in an impeachment inquiry. Now, as far as I know, I think there's only one case, and it's a very recent case, that discusses whether what Speaker McCarthy did is enough to launch an impeachment inquiry. And this came up when the House under Speaker Pelosi was trying to get redacted portions of the Mueller report, portions that had been redacted because they were grand jury materials. And they made I think it's technically called an application for that to the chief judge of the district court in D.C., who at the time was the very same Judge Howell, who we discussed earlier. And she held that there need not be a formal vote in order to open an impeachment inquiry. I have no idea who's right between her and Speaker Pelosi and the new McCarthy position on the one hand and the position of OLC on the other hand. Both Judge Howell and OLC go through all kinds of history in discussing their opposing positions.
So if I can jump in and take this opportunity to launch a vicious attack on OLC. So, yeah, I'd like to go back to 2019. They, as you may recall, the Ukraine scandal broke in August of that year. And a couple weeks later, Speaker Pelosi announced that there would be a impeachment inquiry related to that matter without having a vote. I think, and certainly she was criticized for that. Actually, if you look at what McCarthy said, he didn't actually say, I mean, he may have said this somewhere, but in the letter that he wrote in early October 2019, he actually didn't say that she had to have a formal vote. He actually was sort of vague on this, but my reading of it was he wanted to know whether she was going to have a formal vote, but he didn't actually want her to do that. What he did ask was for there to be procedures in place to protect the president's due process rights. What really happened was that on October 8th, the White House counsel sent a letter to the House, Speaker Pelosi and the committee chairs who were involved, basically saying, we're not going to cooperate at all with your investigation. And he gave a number of reasons, one of which was that there was not a formal House vote taken, although it was pretty clear from the letter that he wasn't going to cooperate regardless. But interestingly enough, he did not claim that he had any advice from OLC on the matter. And throughout October, there are a number of letters from different departments saying we're not going to respond or we're not going to comply with your subpoena because we've been told the White House has told us that we're not supposed to, and that this is not a valid impeachment inquiry. But none of them either cite OLC as giving them that advice. Fast forward to January of 2020, and OLC comes out with this formal memo in the impeachment trial in which they say that the impeachment inquiry was invalid and therefore the subpoenas were invalid. And they say that they gave that verbal advice in October. They don't say exactly when, but they say it was sometime. At several places, they imply it was sometime prior to the House taking the formal impeachment vote, which was on October 31. So sometime in October, allegedly, OLC gave this advice, even though it seems pretty clear to me that the White House went and did this without relying on any advice from OLC. I have filed a FOIA request to try to get information to find out when this advice was actually given. And so far, I have been unsuccessful in finding out if and when OLC actually gave the advice verbally. However, on the sort of the legal issue, the OLC's legal analysis, I agree you can argue it either way on whether an impeachment inquiry needs to be formally authorized. But there was one part of the opinion that I thought was just completely ridiculous, which is they said that even though the House's subpoenas had also cited their oversight authority, they still shouldn't be considered valid because even though, yes, they could have done this as an oversight inquiry, it was clear that the real purpose of the investigation was impeachment, and therefore that somehow made it invalid to conduct this investigation at all. And it seems to me that part of the opinion is completely ridiculous. And I wonder whether the Biden administration will even follow that, because in part, OLC was relying on the memo that they wrote regarding President Trump's tax returns. And I believe the Biden administration actually withdrew that opinion because it was based on this idea that the executive branch can sort of second guess what the congressional purpose is behind an investigation, which is essentially the same thing OLC was saying in that January 2020 memo. So it seems to me that if the House does go forward with this impeachment inquiry and issue subpoenas, if they rely on both their oversight and impeachment authorities, I think maybe the Biden administration will find it difficult to just say these are invalid, but we'll see.
So I want to leave us a little bit of time to talk about a new arising matter. So far, we've talked about a number of cases involving things happening in the past, but I want to touch briefly on Senator Bob Menendez, who has been indicted for, as the charges allege, accepting hundreds of thousands of dollars in bribes in exchange for trying to advance Egyptian interests in the United States. By my last check, about 30 Democratic senators had come out saying that he should step down. But that's not enough. So, Eric, maybe I'll turn to you to ask a little bit about what are the Senate's actual options for getting rid of Menendez? What are his options for fighting that effort? And how has the Senate dealt with members experiencing these kinds of troubles in the past?
Either house can expel a member by a 2/3 vote. And that's obviously a lot. And it requires, in a divided Senate, substantial support by members of both parties. And I would note that at last check, you said around 30 Democratic senators have called on Menendez to resign. I believe the number of Republican senators as of yesterday was 0. So it seems at this point unlikely that he would be expelled. If something changes, the Senate can pretty much handle it the way the way one would interpret current case law. The Senate can pretty much handle it the way that it wants. I think what typically happens is that they refer to an ethics committee, which conducts an investigation and then makes a recommendation that the full Senate can either accept or reject. Senator Packwood in 1995 there was a referral to the ethics committee due to charges of sexual harassment, and also by trying to extract financial favors from people who had interest in specific issues of legislation. And there was a recommendation that he be expelled, actually, but he mooted that by resigning. Before that, in 1982, there was a member of Congress from guess what state, Quinta?
Was it the great state of New Jersey?
It was the great state, your home state of New Jersey.
It's part of our culture.
Named Harrison Williams, a Democrat who was convicted for taking bribes in what was known as the Abscam case, and he stayed on through his conviction. The Ethics Committee, not surprisingly, recommended that he be expelled, and prior to a Senate vote, he resigned. And before that, you've got to go back, I think, to like the 1920s to find someone who even resigned in following an investigation by the Ethics Committee. So it seems that Menendez is likely to hang on if he wants to, and either decide to face the voters or to retire on his own terms.
Mike, is there anything you'd want to add to that?
Only that technically the Senate could vote to expel him without holding like a hearing or anything, but as Eric indicated, that would be completely contrary to any kind of precedent. So I think he's entitled to investigation and a hearing, and presumably that would happen before the Ethics Committee. Normally, the Ethics Committee waits when there's a parallel criminal investigation and waits to see what the outcome is. But what the Senate could do is say, no, we don't want to do that in this case. We're going to investigate, and if that's a problem for Senator Menendez because it interferes with his ability or the Justice Department, for that matter, it interferes with their ability to prepare for their criminal trial. That's too bad. We have an independent constitutional obligation here, and so we're going to go forward with the ethics proceeding. That I think they have the perfect power to do, and that's presumably if they want to do something, that's what they would do.
All right, let's leave it there. Mike and Eric, thank you for joining for our quick overview of the many, many things that are happening in Congress. And we didn't even talk about the potential shutdown.
Good, because I don't know anything about that.
Yeah, nor do I.
All right. Thank you again.
Thanks very much.
Thanks, Quinta. Thanks, Molly.
Thank you.
The Lawfare podcast is produced in cooperation with the Brookings Institution. You can get ad-free versions of this and other Lawfare podcasts by becoming a Lawfare Materials supporter through our website, lawfaremedia.org/support. You'll also get access to special events and other content available only to our supporters. The podcast is edited by Jen Patja-Howell, and your audio engineer this episode was Noah Mosband of Goat Rodeo. Our music is performed by Sophia Yan. As always, thanks for listening.